It's five. So it's 11:05. Good morning, everyone. My name is James Collier. I'm an employment solicitor here at Hanne, and we're here today to talk about disciplinary and capability management procedures, getting it right when you apply those procedures in the workplace. So the agenda for today's talk, I'm going to talk about the statutory potentially fair reasons for dismissal, of which there are 5. And then I'm going to focus on 2 of those reasons, which is, one is conduct. So focusing on the application of a disciplinary management procedure in relation to misconduct or gross misconduct. And then capability is another statutory potentially fair reason for dismissal, and we'll deal with capability management procedures as the second part of the talk. So statutory potentially fair reasons for dismissal, there are 5, and I mentioned 2. So misconduct is one, and misconduct can be characterised as either a lower level misconduct or a more serious, higher level gross misconduct or serious misconduct. And the second one, capability, and the wording there in the statute is in relation to an employee means his capability assessed by reference to skill, aptitude, health, or any other physical or mental quality. So that can be your capability to perform your role at the required standard, and or your capability to perform your role due to health or ill health. And the remaining potentially fair reasons for dismissal are redundancy, and that's further to a statutory definition of workplace closure or a diminution in work. Illegality, that would it would be unlawful to employ or to continue to employ the person. And there's a catch-all really, some other substantial reason, SOSR as it's sometimes referred to. And under that heading comes things like a breach of the implied term of mutual trust and confidence, for example. Today, we're going to deal with the first 2 on that list, misconduct and capability. And the first of those, misconduct. So any type of misconduct in the workplace usually leads on to a disciplinary management process. And in any application of that disciplinary process, the employer and the employee is well served by reading and applying the ACAS code on disciplinary and grievance procedures. So ACAS is an employment and conciliation service. It's a neutral body, centrally funded, and generates advice for both employers and employees. And the code on disciplinary and grievance procedures has what we call a statutory basis, so that if an employer unreasonably fails to comply or apply the code on disciplinary procedures, then any tribunal claim for unfair dismissal compensation can be increased by up to 25%. And we'll deal with that a bit in a minute. But the code on disciplinary procedures says that a reasonable and fair disciplinary procedure should include an investigation of the disciplinary allegation, where the employer must inform the employee in writing of the allegation and that the investigation will take place. And here, the more serious the allegation and the potential consequence, possibly dismissal of the employee, the employment tribunal would be looking for a more detailed investigation and a series of, for example, investigation meetings with different witnesses to take their witness evidence. And once the investigation is complete and the employer has a sense of whether that requires formal action to be taken, if it does, then the employer would invite the employee to a disciplinary hearing in which the invitation should be in writing to the employee. The letter to the employee should include a clear explanation of the alleged misconduct or poor performance and a warning that the dismissal may be an outcome to the hearing. And it's a good time at that point to provide copies of any documentary evidence to be considered at the hearing and inform the employee that they have a legal right to a companion, which is a trade union or a colleague from the same workplace at the hearing. Now, sometimes, if it's serious misconduct, an employer may consider suspending the employee from duty or from work so that they are directed not to attend the workplace or carry out work under the contract. And if the employee is suspended from work, it should be on full pay under the terms of the contract, and the contract should authorise that suspension, and the disciplinary policy usually deals with that. And the letter explaining the suspension should make clear that the suspension does not indicate any interim or preliminary findings to the disciplinary process, so that it is a neutral act. However, the tribunals have noted, suspension is often not a neutral act. It disadvantages the employee. So tribunals have determined that even though an employer may have contractual authority to suspend an employee, it should be for as short a period as possible, and the investigation of the disciplinary allegations should not be delayed if the employee is suspended. So what happens at a disciplinary hearing, or what should happen? The disciplinary hearing should be chaired by a senior manager with authority to decide the outcome, and if that is dismissal, that should be a manager that has authority to dismiss and who has not already been involved in the investigation. At the meeting, the employer should explain the complaint against the employee and go through the evidence that's been gathered, and the employee should be allowed to set out their case and answer any allegations that have been made against them. Also be given an opportunity to ask questions and present any evidence and call witnesses, and raise points about information provided by the witnesses. So it's a little bit like a cross-examination, or certainly a probative questioning of the witnesses brought by both the employer and the employee. And where an employer or an employee intends to call relevant witnesses, they should give each other advance notice of that before the disciplinary hearing. And that's important from the employee's perspective as well as for the employer to do. And if a worker's chosen companion is not available at the time proposed for the disciplinary hearing by the employer has a legal obligation, must postpone the hearing to a time proposed by the worker, provided that that alternative time is reasonable and not more than 5 working days after the original or the first date proposed by the employer. So there is a legal obligation on the employer to adjust the disciplinary hearing date at the request of the employee if their companion cannot attend the first dates proposed. Now, after considering all of the information, there are 2 main aspects to the decision of the disciplinary hearing manager, and that is whether the disciplinary chair upholds the allegations of misconduct, and if those allegations of misconduct are upheld, what the sanction should be. And in reaching the decision, the disciplinary chair should take into account any explanations provided by the employee and look at the whole circumstances of the matter, because that's very much what a tribunal would do when weighing up the decision making of the employer. It looks at all of the circumstances of the case. The disciplinary chair should look at the employee's disciplinary and other general employment record, including any live warnings on their file, and the action taken in previous similar cases. So employers are, it's considered reasonable to treat a similar disciplinary allegation that's found proven in the same way as a previously decided case on that. And decisions that are too far apart in that effect may be found to be unfair. And so treating people similarly in similar cases is a core concept of disciplinary action. Whether the dismissal and disciplinary procedure indicates the likely penalty. And for example, there often disciplinary procedures and policies provide very clear examples of what gross misconduct is. It's fighting at work, any kind of harassment on under a protected characteristic basis, theft, damage to the reputation of the employer by conduct, either inside or outside work. So very clear definitions, and so the policy often points the manager towards the likely penalty, and whether the penalty is reasonable and matches the offence or complaint. And that's sometimes about the manager taking a step back and saying, am I deciding here something that is within a range of reasonable responses of a reasonable employer? And the decision might be, so the outcome of the disciplinary action is either to take no action against the employee, issue the employee with a verbal warning, a written warning, or a final written warning, order a demotion, a deployment, or a dismissal. And that dismissal can be either on notice, so if the employer decides that the employee is guilty of misconduct, but dismissal is the appropriate action, then dismissal with notice would be the appropriate sanction. Or if the employer decides that the employee is guilty of gross misconduct, so really serious misconduct, then dismissal without notice may be the appropriate and reasonable response from the employer. And the employer may order any other action that may resolve the problem, such as a mediation meeting between the employees and co-workers. Appeal hearings, so all workers issued with any form of disciplinary sanction, from a first verbal warning to immediate summary dismissal, must be given the opportunity to appeal the disciplinary outcome and sanction as provided for within the ACAS code. And the opportunity to appeal the sanction, any outcome, is part of a fair and reasonable disciplinary process of a reasonable employer. A failure to offer an appeal is likely to amount to a procedurally unfair dismissal. And if possible, the appeal hearing should be chaired by a different manager, one not already involved in the investigation or disciplinary hearing, and again with the authority to either overturn the decision or uphold it if necessary, the original disciplinary outcome, that is. And the employee has a legal right to a companion, and again the meeting must be postponed for up to 5 days if that companion can't attend on the first date. And consider whether there is any substantial new evidence, that's one ground of appeal, so that a full rehearing of the initial disciplinary evidence is required, or if the appeal is on more limited grounds, for example, that the sanction was disproportionate or unfair. And on that basis, it would be limited to the appeal considering the sanction and the reasonableness of the sanction. So, in an unfair dismissal claim, the tribunal would be considering what is the statutory potentially fair reason for dismissal, and the employer would likely be arguing, well, it was the employee's conduct that was the reason for my decision to dismiss them. And then they would be looking that when applying the test under section 98, subsection 4 of the Employment Rights Act, which is this in words, so taking into account all of the circumstances of the case, did the employer act reasonably in treating the given reason for dismissal as sufficient to justify dismissing the employee? And this question requires the tribunal to consider whether the employer acted reasonably in dismissing the employee for the reason given, and whether the employer applied a fair procedure leading to dismissal. So there's sort of two questions in an unfair dismissal claim. Well, three. What was the reason for dismissal? And if it's conduct, was a fair procedure applied when reaching that decision? And overall, was it within the range of reasonable responses of a reasonable employer to dismiss for conduct on that occasion? And in misconduct cases, the employment tribunal will employ the Birchall test of, excuse me, of deciding whether, it will ask itself three questions. Did the employer genuinely believe the employee to be guilty of misconduct? Did the employer have reasonable grounds for believing the employee was guilty of that misconduct? And at the time it held that belief, had the employer carried out as much investigation as reasonable in the circumstances? So you can see from that test that it's not necessary for the employer to hold conclusive evidence of the gross misconduct it alleges, for example, theft. Let's use an example. So if I allege an employee is guilty of stealing something from the workplace, I must, in order to show that that was a reasonable and fair dismissal for that reason, I must be able to show evidence that I genuinely believed the employee to be guilty of that theft, and that I had reasonable grounds for that belief. So some evidence that led me to believe and that I was relying on for my genuine belief, and that I'd carried out a sufficient and reasonable level of investigation into my allegation in order for me to hold those reasonable grounds in a genuine belief. So conclusive evidence not required, and the tribunal will determine whether the employer acted within quite a wide range of reasonable responses. It will not substitute its view or its decision making for the employers. The questions it will ask itself are: what was the reason for dismissal? Did the employer carry out a fair procedure? That's the ACAS code as we've explained it. And was it reasonable for the employer to dismiss for that reason in these circumstances? And in answering that question, in a misconduct case, it will go on and ask itself the virtual questions about genuine belief held based on reasonable grounds following a reasonable investigation. So that's a misconduct dismissal in 3 meetings, really: investigation, disciplinary hearing, and appeal hearing. I'm now going to go on and talk about capability dismissals. And that is where, if we jump, I'm sorry to crash your eyes, but we're going to jump back to the statutory fair reasons for dismissal. And capability is in relation to an employee, means his capability assessed by reference to skill, aptitude, health, or any other physical or mental quality. So there are 2 main capability procedures, and that is one where an employer is managing somebody who doesn't have a health condition that impairs their ability to either attend work or perform their role at required standard. And so that's about performance management, setting the required expectations and objectives, and managing that under a SMART action plan. So specific, measurable, achievable, recordable, and timeable goals, written down and communicated clearly to an employee. I'm going to focus my capability dismissal on a somewhat probably more commonly experienced situation whereby the employee is on long-term sickness absence, and the employer has to manage that in a way that is both fair and reasonable to the employee, but also takes account of its business needs and activities, and manages its workforce effectively. So, capability dismissals. Formal capability management can be applied due to sickness absence and due to poor performance or not meeting required standards at work. Usually, employers apply capability procedures to manage no-fault sickness absence and performance issues related to health. Persistent non-completion of contractual duties following training and support interventions can also be dealt with under a misconduct or conduct disciplinary procedure, if provided for within the disciplinary policy, that is. So it's really important to identify which procedure you are applying, either conduct or capability, and if capability, what kind, sickness absence or performance management, as the tribunal will look for different procedures to apply and different evidence to have been considered by the employer, depending on which one you are applying. So dealing with employees on sickness absence, the main issues an employer will consider when dealing with employees on sickness absence include their entitlement to sick pay, either statutory sick pay or contractual sick pay. The reasons for the absence and whether that's genuine. And this will entail ascertaining the true medical position and involve seeking a medical report often. Whether the incapacity has been caused by workplace factors such as stress or bullying, or an accident at work, for example, causing injury. Where the absence coincides with any periods of holiday, how do you deal with that? And whether the absence is related to a disability, that's a statutory disability, and whether any reasonable adjustments may need to be made under, and I'm specifically talking about there, the Equality Act 2010, disability status and reasonable adjustments obligations. Oh, sorry. Sorry. Here we go. Sorry, my apologies. Considering whether the employee may be eligible for permanent health insurance or ill health retirement if they've been off on long-term sickness absence and they may not be able to achieve a return to work, and whether dismissal is appropriate, and if so, ensuring a fair process or procedure is applied. So, one of the things your employers are going to be doing in managing long-term and short-term persistent sickness absences is using, storing and processing sickness absence data. And data concerning an employee's physical or mental health is characterised as special data under the Data Protection Act and under the retained EU law and data protection regulations. And employers need a lawful basis for processing it. So employers may wish and also have obligations under the safe storage and confidential management of that data. So employers may wish to consider establishing separate categories for recording disability-related absences and pregnancy-related absences and absences related to workplace injuries, for example, for the following reasons. Employers need to discount pregnancy-related absences if considering disciplining or managing formally an employee for high levels of sickness absence, taking account of their absence as part of a performance appraisal or pay review, or relying on data for redundancy selection exercise. So an individual's attendance level at work should not be used against them detrimentally if any of that is related to pregnancy-related absence. And disciplining or formally managing an employee for disability-related absence might be discriminatory. Such absences should therefore only be taken into account if the employer is satisfied that all reasonable adjustments have been made and taking into account of this data is proportionate and is towards achieving a legitimate aim. That's one of the defences in respect of an indirect discrimination claim. And if the employer is responsible for the employee's ill health, it will normally be expected to put up with a longer period of sickness absence than would otherwise be reasonable for the purposes of unfair dismissal law. And in addition, the employer may wish to avoid compounding any potential risk when it may already be at risk of a claim for personal injury, for example. So this data is special data. It must be stored and managed in accordance with the data protection laws, and an employer may consider separating the categories of sickness absence data into pregnancy-related, disability-related, and injury at work-related absences, because different considerations need to be applied to those categories of sickness absence. So we've just dealt with two of those, and I thought I'd put a little bit more meat on those bones. So pregnant employees have a protected period that lasts from the conception up until the end of the statutory maternity leave period, or in some cases just 2 weeks after the pregnancy. So dismissing an employee or subjecting her to any detriment as a result of a pregnancy or maternity-related illness occurring during the protected period is unlawful and could lead to claims for pregnancy or maternity-related discrimination. And if the employer has a policy of initiating a procedure that may lead to dismissal once an employee reaches a certain level of aggregated sickness absence, and more employers do use those sort of sickness absence triggers, the employer must not take into account any absence related to pregnancy or maternity that falls within the protected period. So the employer must discount that pregnancy-related absence when applying those triggers. And lastly, their disabled employees have a legal right to reasonable adjustments to facilitate a return to work or to avoid disadvantages caused by the employer's policies and procedures whilst at work, and legal protection from less favourable and disadvantageous treatment related to their disability. So it's really important, as part of any sickness absence management procedure, that an employer asks questions about the disability status of the employee. And I'll deal, I hope, in a minute with the test for disability status, but I'll just say it now while we're here talking about disability. A person is disabled under the Equality Act if they can show they have a long-term condition, any condition, doesn't matter about the diagnosis, that causes them substantial adverse effects on their ability to carry out their daily activities. So a very wide definition of disability there under Section 6 of the Equality Act. And if they have such a condition that is long-term, causing those difficulties, then an employer has a legal obligation to make reasonable adjustments, and the employee has legal protection from less favourable treatment because of that disability and disadvantageous treatment related to consequences that may occur or arise because of their disability. Now, so a sickness absence management procedure looks something like this. Meeting 1, where I've focused on long-term sickness absence, but I suppose short-term sickness absences could follow roughly the same procedure, but would just have slightly different considerations and questions for the employee within them. So long-term absence, first formal meeting. In a first formal meeting to discuss long-term absence, the employer is likely to want to explore the following issues. Any return to work date, which is likely based on the evidence, and arrangements for future contact if the employee is going to remain on sickness absence, and perhaps further medical review if the employee's condition is either variable or the employer requires more advice on how the medical condition, health condition, may impact the employee at work, and whether there are any further meetings required under the sickness absence procedure. And at this first meeting, an employer is thinking about, but perhaps not impressing upon the employee, how long the employer can wait for the employee to return to work. And it is useful to have an open dialogue about the expectations of when the sickness absence management procedure may be exhausted, and it might be reasonable at that point for the employer to require, I suppose, the employee to either be in a position to return to work or to an adjusted role, or to return to work to their role. And you're definitely thinking about whether the employee has a disability under Section 6 of the Equality Act, as I've just described it. That broad definition of whether somebody's condition causes them substantial adverse long-term difficulties managing their daily activities. And daily activities can be anything: walking, lifting, carrying, shopping, reading, writing, socializing. Very general daily activities are the threshold, and it's a functional assessment of that individual's functional ability related to their long-term health condition. And so the status of disability really is a legal question rather than a medical one, and determined in the first instance by the employer, not the employee really, or the doctor. So the employer makes its own mind up based on the information given to it by the employee and the employee's medical doctors. The employer determines, do I consider that your condition satisfies the definition of disability as I understand it? It's a functional legal definition, not a medical one. And so the final determinant of whether the employee is a disabled person at the relevant date would rest with the tribunal and not the doctor, for example. So the tribunal judge will decide in the end. And whether the employee perceives they can return to their previous job, and with or without adjustments, and whether the employee perceives they can return to their previous job, provided the adjustments are made. And can those adjustments be made? Does the employer consider those adjustments to be reasonable in all the circumstances? And there again, if the employee is disabled, the employer will have a positive legal duty to make any adjustments that are in fact reasonable in the circumstances to make. And again, the employer determines what's reasonable in the circumstances in the first instance, but if challenged in the tribunal, then the tribunal judge would have the final say on actually that was reasonable in those circumstances, and there has been a failure to take reasonable steps on behalf of the employee to alleviate their disadvantages. And that's a claim for reasonable adjustments, Section 20, Equality Act. So what alternatives the employee may wish to explore: redeployment or application for employment benefits. If really unable to return to work, there may be a process of transition between employment and long-term sickness benefits, for example. And it's important that the employer identifies whether there are any contractual or other rights to insurance benefits or contractual long-term sickness benefits at these meetings. And what are, if any, the mechanics of a return to work programme? So that's meeting one. It's really a fact-finding meeting. What are we dealing with? What are the health circumstances? Is there anything I can do reasonably to adjust what I'm expecting of you under the contract or from my environment as the employer to enable the employee to come back to work? But if that first meeting hasn't been effective at enabling or facilitating the employee's return to work, the employer may want to consider whether a second formal sickness absence meeting is required. And at that meeting, it would be, is this a return to work meeting to consider adjustments or a phased return to work plan? Or is it due to the employee's ongoing inability to work, their long-term sickness absence, or their persistent intermittent short-term absences, so that formal attendance or sickness management may need to apply? And you're looking at the GP fit note to, does it certify the employee as being fit to work without any adjustment, in which case you would be planning on the employee's return to work? Is the employee fit to work, but only with adjustments? And sometimes the GP fit note does specify certain adjustments the GP considers helpful from the employee's health position. Or is the GP fit note certifying the employee as not fit to work, still at the second stage of the formal absence management process? So it's important again to consider reasonable adjustments for disabled employees, and a reasonable adjustment might be a phased return to work, amended work times and duties, redeployment to a different role, relocation, increased support, or the provision of some auxiliary aid or an amendment or adjustment to the environment. And here I've put the test here for disability status just at the end here. So a person is deemed disabled, so they automatically have disability status if they have a diagnosis of cancer, MS or HIV. So any employee with that diagnosis can rely on automatic disability status under the Equality Act. But a person is considered disabled if they meet the following Section 6 test. So they experience substantial long-term adverse effects on their ability to carry out normal daily activities due to their condition, which is a physical or mental condition. And you will also be considered, so that's the definition of disability. You'll also be considering providing to the employee at this meeting an explanation of the ongoing effects of this employee sickness absence is having on the business and all their other employees. It's important to set this out because that is ultimately going to be one of the reasons for dismissal, is the ongoing and longer term effects on the business and business activity of the employer. And that's what in the end tips the scale of reasonableness over from being not reasonable to dismiss at this stage, but being then therefore fair and reasonable for a reasonable employer in these circumstances to decide to dismiss at this date. And that date, well, date X, whatever that date is, that's going to be different for each circumstance and each individual presentation of this sort of issue, because each individual is going to present with different medical evidence, be involved in different activities, be requiring different adjustments, and with different considerations to take into account for each employer. So there is no definitive time when it's reasonable to dismiss an employee who is on long-term sick leave. That's an individual question that must be answered after all of these considerations have been taken into account. Again, so an employee has the right to be accompanied at a statutory right, a legal right to be accompanied at a disciplinary meeting, which is defined as a meeting that could result in any of the following. So a formal warning being issued to a worker, the taking of some other action in respect to a worker, and a confirmation of a warning or some other action. So a long-term capability sickness absence meeting at which you are about to issue a formal warning for absence is a meeting at which the employee has a legal right to be accompanied. Section 13, Employment Relations Act 1999. So it's not just a disciplinary meeting, it's a capability sickness absence meeting at which the employer is planning to give a formal warning for absence. And that will be at a sickness absence management third sickness absence meeting, which is sometimes called the capability hearing. And if the employer has applied a stage 1 and stage 2 meeting to investigate reasonably the employee's sickness absence, persistent short-term or long-term, and has made reasonable adjustments for any disabled employee, has discounted disability-related and pregnancy-related absences in its triggers, then escalation to a stage 3 capability hearing where the employee risks dismissal can be reasonable, may be reasonable in these circumstances. The employee should be invited to any stage 3 capability hearing in writing and clearly warned that dismissal was a risk or a formal warning may be issued at the stage 3 hearing. The employee has a legal right to a companion, trade union or colleague at this meeting, and the same rules apply on rescheduling. And a clear and well-documented explanation of the ongoing effects of the employee's absence are having on the business and other employees should be given and reiterated in writing to the employee. Now, I have whizzed through those, and what I'd like to do now is just, I haven't been checking the questions, so I'm just going to stop sharing my screen and check in the questions if there's been any questions, and there has not. There has been none. So, does anyone have any questions on the disciplinary procedures that I've set out? That was a 3-stage process: investigation, disciplinary hearing, and appeal hearing, or the capability management process that I've set out, and that was a stage 1 meeting, a stage 2 meeting, and a stage 3 capability hearing. And I should mention, in any formal outcome, as I mentioned with the disciplinary action taken by that may result in a formal warning or a dismissal, any formal warning given further to a capability procedure or any dismissal related to capability, all those individuals must also be offered the right of appeal to those decisions. And that is part and parcel of that fair procedure, capability management procedure being applied. So, stage 1, stage 2, finding out about the employee's condition. Stage 3, capability hearing, making a formal decision on the sickness absence, and then an appeal of those decisions and outcomes would make up a reasonable and fair process. I can see we have a question. I'm going to read it out. Can stage 1 and stage 2 meetings under capability relating to long-term sickness be combined before going into the formal 3rd stage? I mean, my advice there would be, it would not be in the employer's or the employee's best interests to combine the stage 1 and stage 2 meetings, because what you're really trying to do is generate evidence, documentary evidence, that you have explained to the employee clearly the procedure that will be applied, that you've applied the procedure fairly and reasonably and in the same way as in accordance with everyone else, so that you've applied it equally. And by combining them, what happens is the procedure towards the employee's dismissal is sped up, and that increases the risk of a claim for unfair dismissal, and potentially the other claims that we've talked about, disability discrimination most importantly. So there is a potential for the employer to miss things, that is, miss questions on disability status, miss evidence on what might be a reasonable adjustment at certain stages. And also there is an increasing risk that the employer is not acting within the range of reasonable responses of a reasonable employer when dealing with a long-term sickness absence by combining those stages, thus disadvantaging the employee really, and therefore increasing the risk of a claim for unfair dismissal. So my advice would be, you can, but you increase the risk of these claims being brought against the employer as a consequence of doing that. And I think the separation of these stages allows the employer to go through a clear and reasonable consideration process, assimilating and gathering together the required evidence on the employee's health and capability to perform their role, and therefore increases the chance that the employer will be found to have decided to dismiss the employee at a reasonable time and have applied a reasonable process. Does that answer your question? I hope so. No problem. Is there any other questions? I don't want to leave anyone with any burning questions. It wasn't I accept it wasn't a particularly in-depth disciplinary and capability management procedures presentation. I really wanted to cover the basics so that perhaps I can build on that in the future, in the next presentation, deal with something a bit more a discrete topic within those headings. So I'm not seeing any further questions. It is 10 to 12. Thank you very much for coming today. I'm very grateful, and I hope you all have a really good rest of your day. I would say if you need any help with disciplinary or capability management procedures, Hanne & Co have a specialist employment law department, and I'm here to assist anytime. Please do give us a call. Thank you very much for attending today. I will end the meeting now and send on the handout to your emails. Thank you very much.